Namaste, everyone. My name is Mahir Sood, and I am one of the moderators today here. For the benefit of our viewers who are the distinguished lawyers, academicians, and legal scholars, and rather learners, I would like to say I welcome you all on the behalf of the Bar Council of Punjab Haryana, which is the principal parent governing body, statutory body for the lawyers across the state of Punjab and Haryana. I am delighted to welcome you all to today's session on the evolving landscape of data protection and privacy laws. Our discussion today will be enriched by insights by global leaders in technology law, data protection, and emerging legal frameworks. Ladies and gentlemen, we are at a significant juncture in the history of data governance. The world is grappling with rapid advancement of technologies, and we pose some unique challenges. And these challenges relate to the privacy and the data protection. India's recent Data Protection Act has sparkled diverse opinions, and today we seek to understand its implications and global intersections. Before we begin, I encourage you all to consider the wider context of data privacy, how it touches your personal lives and the digital economy. Think about the headlines we've seen, the daily data exchanges you participate in, whether it is the apartment where you're living in, the register that is filled by you and the visitors that is leaked to the larger prospect. We have seen bigger data leak like WikiLeaks in the past. This session is an opportunity to reflect on the balance between the convenience and the security on today's digital era. As we embark on this critical dialogue, I am honored to introduce to you our esteemed speakers. An internationally renowned scholar, expert, and consultant on the ICT law and data protection law. He was a professor of law at the Faculty of Law, University of Malaya, Malaysia. Currently, he is a visiting professor at the Faculty of Law, University of Atmajaya, Indonesia. Pardon my pronunciation. He is also the legal advisor and data protection consultant to Strats Interactive Pte. Limited, Singapore, senior advisor to Schindler Law Firm, Jakarta, and a member of the Academic Advisory Council of the Asia Pacific Institute of Digital Economy, also known as APIDE, in Tokyo. He is a founder and advisor of the Bali International Arbitration and Mediation Center and an expert council member of the Pandya Institute. Professor Abu has been widely consulted by governments and private entities worldwide. He's been advisor to various governments. He is also handcrafted, and he is a himself when it comes to the Personal Data Protection Act 2010 in Malaysia. We welcome you, sir.
Thank you so much.
Ladies and gentlemen, my second panelist here is from Nigeria. We have our very own Attorney Temi, who is an authority in the data protection laws herself, who is a passionate lawyer and practices in the courts as well as the constitutional courts across Nigeria. Our third panelist, ladies and gentlemen, is Mr. Raj Pagaria, who happens to be from India. He himself is an authority on the data protection laws. He's a young and dynamic lawyer who started his passion way back in 2016 when he joined the legal profession through various intricacies, and has also helped the various persons who are the victims of the sexual data protections, data leaks, and he has ensured that their data is not breached further and ensures the damage control, ladies and gentlemen. We welcome you, sir.
Thank you. Thank you so much, Mahir.
So, ladies and gentlemen, I'm going to start this esteemed panel discussion with our first opening remarks. I'm going to start with Professor Abu, followed by Attorney Temi, and then Raj Pagaria. The floor is to you, sir. Opening remarks in 60 seconds.
Thank you so much, Mr. Chairman, moderator, for giving me the opportunity to to participate in the discussion. I think it's very timely, simply because of the fact that India has enacted the law on data protection 1.5 years ago, and recently they came up with the regulation. So the regulation for public comments, I was informed. So I think this is a very timely discussion for us to have. Yep. And I'm looking forward if there are questions from the participant in the session.
Thank you. Thank you, sir. We are thrilled to have you. Let us move on to Attorney Temi. Your opening remarks, ma'am.
Sorry, thank you very much. Thank you, sir, to the Bar Council of Punjab and Ayana for having me, and I look forward to this conversation. And it's interesting to note that data protection laws are evolving all around the world. So just as Professor Baka mentioned, India recently enacted the DPDP, and in Nigeria, recently we also had the NDPA, and we recently had the guidelines as well on how to implement this law. So I look forward to this enriching conversation. Thank you.
Thank you. That's very interesting to know. We will come back to you, ma'am, and we would like to have a very elaborate viewpoint on how Nigeria has gone through the data protection like you just gave in the opening remarks. Let us move on to Mr. Raj Pagaria.
Hi, thank you. So every country has its own journey of recognizing privacy as a right, and then finally moving on to having a full-fledged law in the form of an act or a legislation, and then come up with different sets of rules and regulations to affect how the compliance would look like. So, in that context, I think we have come a long way from privacy being recognized as a fundamental right in the Justice Puttaswamy judgment to finally having a law, and then the rules are up for public consultation. And I'd be glad to hear from my fellow panelists about what their experiences have been and how we can get something positive to implement in India as well. Thank you so much.
Thank you. Thank you so much, Mr. Pagaria. So let's take this panel discussion ahead with the first question I have for Professor Abu. So my first question to you is, Professor, Malaysia has set a commendable example when it comes to data protection laws. What lessons can India take from Malaysia's approach?
Thank you so much for the question, Mr. Chairman, Moderator. Yes, Malaysia was the first in Southeast Asia country to have data protection law enacted. It was enacted in 2010. I'm glad to say that I was involved in advising and crafting the law for Malaysia back in 2007. Then the law was passed in 2010. Then we gave a grace period of 3 years for companies to get ready to before the law was enforced. So Malaysia was the first in this part of the world in Southeast Asia to have the law. And yes, as you said, we have learned from countries around the world how best to implement the law. And recently, Malaysia came up with the amendment to the law to include some international, perhaps, features into the law. For example, before the amendment, there was no provision on data breach notification. Now we have data breach notification. Then the appointment of DPO, and the other thing is about the right to data portability, and the government of Malaysia had decided to increase the penalty in case of contravention with the principles of the law. So from 300,000 to 1 million. So these are some of the new things in the act in the law in Malaysia concerning data protections. And these are basically common features, if I may say so, or common denominators of the law on data protection around the world. I think I'll stop there, and perhaps if there are questions for me to clarify. I can't hear you. I lost I lost you.
Thanks.
Yes. So, Professor, what is the penalty? You talked about the penalty. What is the penalty in Malaysia for the breach of data?
It
Civil and
varies.
penal both. Is
It
there any
varies.
penal penalties?
Yes. Of course, in terms of the quantum, it varies from 100,000 to 1 million, as I said just now. And it depends on the seriousness of the offenses committed by what we call as data user in Malaysia. So it's very much depending upon the seriousness of the offense, and it varies, as I said, and it's a criminal penalty, and someone will have to be, I mean, the company will have to be brought to court. But of course, the law in Malaysia allows compound or compoundable offenses allowed in Malaysia. Okay. Apart from that, there are other sort of mechanism how the law is being enforced in Malaysia. Yeah, just like in other countries. For example, you can give written warning and ask the data user to rectify whatever mistake that has been done or whatever gaps that have been, I mean, in existence in the practice of the companies or data users in Malaysia. But of course, in Malaysia, we don't have, our PDPA or Malaysia's PDPA does not allow civil action to be brought against the company or data user.
Okay, that's very interesting to know.
So we don't have that provision under our Personal Data Protection Act in Malaysia.
Okay, so
Right.
it's more of the penal provisions.
Yes, yes. So there will be the investigation will have to be done, prosecution will have to be done, and the court will impose a penalty. But as I said, there are some offenses which are compoundable.
Correct.
All right.
Thank you for those views. Let's circle back to Attorney Temi. We would like to know the same position in Nigeria in respect of the data protection laws.
Okay, thank you very much. So basically the data protection law in Nigeria, we initially had a Nigeria Data Protection Regulation, which was introduced in 2019. So while this laid a foundation, I mean, for data protection, for the Nigerian Data Protection Act, which was later promulgated in 2023. So while the NDPL, the regulation, I mean, laid a foundation, although it was non-legislative and it had comprehensive enforcement powers, and it was also limited in its scope and applicability to data protection challenges. So even though it also had the penalty mechanism as well, but because it was not an act in itself, so this necessitated the drafting of the NDPA, and we've had a couple of data breaches. I mean, cybercrime, basically the same types of crime you would have, I mean, globally, because data protection is evolving globally, just like the theme of this webinar. So due to high levels of cybercrime activity, and we needed to increase the demand for stringent privacy laws, and we also needed to aspire with to international privacy standards, such as the GDPR, and also, like we're all aware, the UN Declaration of Human Rights also recognizes privacy. So it was in the need to also aspire to boost investor confidence and to also enable cross-border data flows. Nigeria needed to draft the Nigerian Data Protection Act, which was now drafted and signed into law by President Tinubu in June 2023. In addition, we had regional initiatives such as the African Union Convention on Cybersecurity and Personal Data Protection, also known as the Malabo Convention. This also influenced our legislative efforts. So, I mean, the Nigerian government has also prioritized digital economy development. So we've had the National Digital Economy Policy Strategy. It's a 10-year strategy, I think, from 2020 to 2030. So the establishing the data protection law was identified as a critical step to ensure the success of digital economy and also to safeguard citizens' rights. And this is also to boost investor confidence as well. So thank you.
So, Mike, that's very interesting to know, but I have a counter question as well. For the benefit of the viewers, please explain to us, like Professor elucidated and interestingly said that there are more penal consequences in Malaysia. what is the situation in Nigeria?
In Nigeria, just as in Malaysia, we also have the courts as an instrument of adjudication, and we also have the penalties that accrue to different data controllers and different data processors. And it actually also varies depending on the severity of the risk, just like Professor said in the case of Malaysia. So in Nigeria, if you're a data processor, with more than 10,000 data subjects, then the fine is 10 million naira. So 10 million naira is, should I say, about 1 million is, £1 to a naira is in excess of 2,000. So a pound is in excess of 2,000 naira. So the fine is greater than of 10 million naira or 2% of your prior year's annual gross revenue. So not even, whatever your revenue is as a business. So you just know that if there's a data breach, you're paying 2% or 10 million naira, whichever is greater, as penalty if you're a data processor with more than 10,000 data subjects. And we've actually seen the NDPC actually implement these sanctions. It was implemented last year in respect of a bank called Fidelity Bank. I think the bank was fined to the tune of 500 million naira. Yeah, so I don't have the exact figure off my head. So there are a lot of awareness by the Nigerian Data Protection Commission, and these penalties have been implemented. So just like Prof mentioned, they go with a warning first. The right, just to get the opinion of the other party, of the party that is in breach of the data protection regulation. And if there's no response, then they now go ahead and levy the fine, or if the response is not satisfactory enough. So if it's a data controller or data processor with fewer than 10,000 data subjects, then the fine is the greater of 2 million or 1% of the prior year's annual gross revenue. So again, it depends on the number of data subjects involved and the type of controller or processor as well. And this is also the criminal action path that may be taken against valuators as well. And the valuator may also order the NDPC may also order the valuator to compensate data subjects, that were harmed. So apart from paying the fine to the NDPC, which is the National Data Protection Commission, you also, if you're in breach, are required to pay a compensation to the data subject that were harmed, and you'd also account for any profits that were made from the valuation. So they're also quite stringent as well. Thank you very much.
Thank you. Thank you so much. That was very interesting to know. Different nations across the globe, different laws. Let's circle back to Mr. Pagadia and let's talk about India then. So, Mr. Pagadia, my question to you is, ever since the draft DPDP rules, they have come out, there has been a fair amount of criticism. Where do you stand on how India's data protection laws and framework has progressed in the last 5 years and in the last 10 years?
Okay, a very interesting question, Mahir. And I think this is something that I discuss often with law students while talking about technology and law. So law, as we know, is not as fast as technological developments that we see these days, right? So we cannot decide today that we will be able to regulate technology maybe 10 years down the line. 10 years down the line, it would be different. But at the same time, we cannot sit back and relax and wait for a law to appear that, okay, this is the perfect law. And whenever it comes to laws that are going to regulate on technology, I think we will need to start somewhere and then fine tune it as we implement it. We cannot have an ideal perception right from day one. Something that may be okay for you and 5 others is something that I may not be okay with from a legal perspective. But where I'm not okay with is something where we can consider that as a feedback and see if we can bring that in the form of an amendment or something. So I remember the initial draft that came from the Justice Sri Krishna Committee. I think it was in 2018. So from that, it took us 5 years to finalize the act, right? So we've already taken too long of a time. And now the act came in 2023. The rules have come in 2025. So this is again 1.5 to 2 years gap that is there. So we should not, sit back and further relax and try to get that stage of ideal or oblivion where we would have the perfect law. If we have something, we can start and we can always amend, right? It is not going to be the case that the law is very bad. It is something, yes, it is a start. and once you implement it, you will realize the problems. See, right now, I and anybody in the data protection space in India, we can all talk about potential problems, but not the real problems that would occur when it is implemented. So unless you implement it, you can only talk about problems and end up nowhere.
Yeah.
Rather, we have taken experiences from example. I'm sure Professor Abu would agree that Europe had a 1995 directive. Then they changed it in 2016 and they brought in GDPR. So they have a very mature data privacy jurisprudence when it comes to judgments and interpretations. So we can learn from them
Yeah.
and then we can implement it in our own context. We cannot compare everything that we have today with a jurisprudential database that is 20, 30 years old. This is our context, this is our societal construct, and we have to implement this law in our context as well. So we can start and we can fine tune it over time instead of starting today and then wait for 10 years to bring in an amendment.
Very well said, sir. It's more like we should have started yesterday.
Yes.
Okay.
But well, it takes me to another context. I would like to circle back to Professor Abu. So
Yeah.
my question to you is, now that how do you see the role of the regulatory bodies in ensuring the compliances with privacy laws in rather the Southeast Asia?
You mean in Southeast Asia?
Yes.
Okay. I don't think we should confine to Southeast Asia because, as it is now, there are, I think, 145, if I'm not mistaken, countries around the world that have enacted comprehensive law on data protection. And in this part of the world, in Southeast Asia, Vietnam, on the 30th of November, came up with the law replacing the decree issued 2 years ago. And when I look at the Vietnam's law, there are similarities, and as I said, there are common features of data protection laws around the world. For example, the common features are the obligations of data controllers or data users, specifically mentioned in all the legislation around the world. Then the rights of data subjects or the people or the data subject. And then we have redress or enforcement mechanism and powers and authorities of the supervisory authority. So on that issue of enforcement and supervisory authority, I do recognize that it is very, very important for the supervisory authority to be independent when they implement the law. The whole idea is that they should be able to enforce the law without fear or favor. And a good example is that recently the European Court has imposed a fine against European Commissions for transferring the data to outside Europe and in breach of the EU GDPR. And in the UK, for example, the Office of Parliament's or Parliamentary Office has been fined by the regulator or ICO in the UK. So it is very, very crucial for the supervisory authority to enforce the law efficiently and without fear or favor. Then the law will work. Otherwise, it's going to be difficult. Yeah.
Yes. Professor, the situation in India is also, in my humble opinion, that if we go to the police station for a data breach, they say we have better things to do. Then lawyers like Mr. Pagaria come to the rescue. So, of course, that is there. So what, according to you, can be the internationally best practices for localization of this public acceptance?
I'm not sure, but I've done the research on the proposed law of India, Personal Digital Data Act of India. But I'm not sure now what is a position, whether you have to go to the police in case of data breach. But around the world, again, it is the obligations of the supervisory authority in Malaysia as a commissioner to investigate if there is a breach, and perhaps police can play a role to assist the investigation. So what I'm trying to say here is that it is the role of the commissioner or the supervisory authority to investigate, because they are supposed to be the expert, and perhaps they are given the power to do that. Yeah. What is more important is that the outcome of the investigation will have to be published, because we have to be transparent about the issue. It's not enough to say, yes, we will investigate the case and that's it. So the general public will have to be informed what is the outcome of the investigation, and we can learn from there. I remember there was a case involving a government-owned company in Singapore. It happened, I think, 3-4 years ago, before the law was amended in Singapore. There was a breach involving VVIP, or the Prime Minister of Singapore, and investigation was carried out. A committee was set up. Committee sat and discussed and came up with 400-page report of the incident, on the incident. So from there, the general public and other companies or data users can learn. If you read the report, if you read the 400-page report, you can see the details and what have gone wrong and how to rectify and lesson learned. So I think this is very crucial. Apart from carrying out the investigation, the outcome of the investigation and the full report will have to be made available for the public to read and to learn from that.
Absolutely. Instead of greasing the palms of the police officials, it is imperative that the localization of the data protection laws is absolutely there. So let's circle back to Attorney Temitope and let's ask her, data localization has become a hot topic globally. So ma'am, what are your thoughts on its pros and cons?
Okay, thank you very much for that question. So, well, first of all, so I'd say that there are quite a number of pros. So in terms of the advantages, yes, so I'd say we need more harmonization of laws, and like Prof rightly mentioned, the laws they recognize basic rights, across board. First of all, consent. The data must be processed for legitimate reasons. And again, the organizing body that is in charge reinforcement also has the duty of raising awareness, in the local jurisdiction where those laws are being enforced. So in terms of pros, so I'd say that it would increase cross-border transfer of data, for economic purposes, and it will also increase global trade. So for example, if a country is blacklisted now, if it's not a whitelisted country, because the GDPR has the whitelisted countries, and the NDPR also has the same thing. That was the initial legislation before the NDPR was enacted. So I'd be confident to share data with a country that is whitelisted. However, in terms of multinationals, they usually are required to have standard contractual clauses or the binding corporate rules that that is actually implemented across board in the multinational. So for example, if I work with PZC, for example, we have binding corporate rules. When it comes to data protection, Nigeria, Indonesia, across our jurisdictions of practice. So I think there are quite a number of pros, because we need to share data, to enhance our job roles, not just to enhance our job roles, to enhance the organization's duty as an employer, and maybe for tax reporting purposes as well. So data needs to be shared across board. So I think there are quite a number of pros, especially when it comes to whitelisted countries. And international law is also recognizing the need, and that's why we have conventions such as the ICCPR recognizing that privacy is a human right, and human rights is also recognized globally across the globe. So it's also, among countries in the world. So I think there are a couple of pros. But when it comes to cons, I think the cons probably have to do with divergent laws. And so, for example, the POPI in South Africa is quite different from the NDPA in Nigeria. So the POPI in South Africa actually recognizes some rights, but in Nigeria, those rights are not morally upheld. So, there is a divergence when it comes to ethical views from nation to nation. So I think those are also the cons that may impact, that may affect data protection laws, because I'd say, okay, so, maybe when it comes to the rights of children, for example, in some countries, it's upheld in some countries than in some other countries. Some countries actually have stricter rules when it comes to children's rights or consent, compared to other countries. So those are the cons, because people have divergent views. When it comes to acceptable use, internet policy, for example, in a particular jurisdiction, the view may be, oh, okay, this is acceptable, while in another jurisdiction, it's an outright no. So those are what I'd call the cons when it comes to data protection law. So the cons will not allow for economic development in some cases. When it comes to cross-border trade. So those are the issues. So I think what needs to be done is the regions need to come together and work towards harmonizing the laws. Invite the stakeholders and work towards raising the necessary awareness, and while still respecting the restrictions. We can always have a middle ground while still respecting maybe religious differences or moral differences, ethical views. So I think that would also help to harmonize data protection laws. Thank you.
Thank you for such a detailed and comprehensive opinion on the pros and cons, which takes me to the next question, to our third panelist. Mr. Pagaria, this question is for you. Often we compare the Indian laws with what's happening in the US and Europe or the UK. What do you think about such comparisons in the context of the data protection laws?
Okay. So just as I mentioned earlier, Europe has good about 30 years of jurisprudence on data protection. And they would have also done about 6 to 7 years of groundwork when they brought in the 1995 directive on data protection. So now if you see India, we were late to access the internet, and then we had the IT Act. If you go through the preamble of the Information Technology Act, it is only supposed to recognize electronic forms of communication, transaction, and e-commerce. It might have never been intended to regulate cybercrimes. And in all these years, there has been only one amendment act, full-fledged, to amend the IT Act. There have been some minor amendments here and there. And when the right to privacy was finally recognized as a fundamental right covering informational privacy as well, that was 2017. So the first codified act to exist has come to us in 2023. So that is about 28 years since we started using the internet. Now, to add to this mixture, I would also like to add a couple of stats. I'm not saying these are exact figures, but this would give you a rough idea. So when I started working in this domain about 2014-15, we used to talk about internet penetration rate, right? So it was about 15 to 18% of the total population. Now, 15 to 18% of the total population, if you just focus on the number, it might not seem small. But if you consider 15% of a country whose population is 1 billion plus, that is a decent enough number. And in the last 10 years, that penetration rate has gone to 70%. So there has been 4 to 5 times growth in the number of internet users that we have. Now, all of these internet users that have gotten access to the internet in the last 10 years, we need to understand that there is a lack of awareness in terms of what to do and what not to do, where to sign up and where not to sign up. So the digital literacy that we often talk about, there is one area that we need to work on. Now we are trying to bring in a law to regulate data protection for a mass population. I think there are about 800 million internet users in India right now, right? And all of us can sit in our air-conditioned offices and discuss these issues. But how the people at ground or in rural areas are interacting with the internet, those are the issues that we are not even familiar with. right? So in Indian context, there is big divide, economic as well as social. So we might as well take inspirations from developed jurisprudence. But if you're always going to compare Indian law with countries that are developed or countries that have better economies than us, then I think we would be missing a point. We would, of course, cater to population in urban areas and city centers, but there's a major chunk of population in India that is in semi-urban and rural areas. So we may not be able to create an efficient framework for them. We talk about so many rights that a data protection law has, but let's say we've got the law. Let's say it is going to come into effect in June 25. Just assume, right? It would take us at least 5 to 7 years to explain those rights in languages that people would understand. English is not the universal language in India. You move to different state, language changes. So unless we can communicate the legal framework we have, it is not going to benefit the people who it is intended for. So I'm all in for taking inspirations from the developed jurisprudence, but only take inspiration, don't control C and control V, right? So this is where I stand on this.
Yes. So I have a counter question for Mr. Pagaria. Mr. Pagaria, we have seen, just like the United States has the social security number, India came up with the Aadhaar UID numbers. And there have been a lot of controversies with regard to that. There have been some allegations about the data leaks also. So what is your humble opinion on this issue?
Okay, so for a data protection framework to work, people who store and control data have to be transparent about what's happening, right? You cannot say on one day that there is no leak and then come up with an official explanation next day that a leak has happened. That's not the case, right? If it's a leak, you accept it, you learn it, and you move on. If you see, there are not a lot of publicly listed companies, Mahir, in India that have disclosed that they've faced a cybersecurity incident. Now, in 2025, if all companies are saying that we have had no cybersecurity incidents, what are the hackers and activist groups are doing? Are they doing nothing? I'm sure that's not the case. There's always something happening. We talk about ransomware attack here and there, some DDoS attack happening. But why are listed companies not disclosing? Because there's that lack of transparency. And when I talk about government agencies handling personal information to an extent that they pretty much know everything about me, just to give my fellow panelists an idea of what Aadhaar data entails, it starts with my name, my parents' name, my date of birth, my address, then my fingerprints, and then my iris scans. And then all possible addresses that I would have had, along with mobile numbers and email. And this Aadhaar data is linked with our taxation ID. This Aadhaar number is mandatory for doing everything right now. The law may not say shall, but in practice, it is everywhere. I want to open a bank account, I need Aadhaar number. I want to travel somewhere, I need my Aadhaar number. I want to invest in the market, I need my Aadhaar number. So if you correlate all forms of data that Aadhaar has, they can virtually create another Raj Pagaria, right? So my fingerprints and my iris are my unique identifiers. They have that. So when you have so much of sensitive data, I think there is this quote from Spider-Man where Uncle Ben says something like this, with great power comes great responsibility. And transparency is that one component I understand in terms of that responsibility towards the general public. So I'm not against the idea of Aadhaar, but I'm definitely in for having transparency. See, if Aadhaar is going to make sure that people who are going to need government benefits, those benefits are reaching to them directly, I'm all in for Aadhaar. But it should not be at the cost of security and data leaks.
Thank you for that perspective. It's very interesting to know. And my next question is to Professor Abu. And sir, it is a saying, I read it somewhere in one book, information is the new currency. So with regard to the realms of the technological advancement, we have gone global. Companies are operating with millions of dollars of revenues across various nations. But the governments also are accountable to each other. How can we ensure that there is cross-border implementation of these data protection laws smoothly?
Yeah.
What is your take on it?
I have another version of, data is the new currency. Apart from that phrase, there's also saying that data is the new oil.
Yes.
It shows the importance of data. So, and there are other versions, in fact, data is something else, and so many versions. So, one issue concerning this data protection is about cross-border data transfer. Yeah. So cross-border data transfer is very, very crucial for the international trade, for developments around the world. So you have to transfer data from one country to another to allow companies and business to flourish. So Malaysia, just to take at Malaysia, I mean the situation in Malaysia, we used to have a very restrictive provision on data transfer under the old Data Protection Act. And I'm happy to say that recently it has been amended basically to allow data to flow from Malaysia to other parts of the world, as long as the data is protected by the company which receive the data in other parts of the world. So I think that is the approach that should be adopted around the world, as long as you can protect the data wherever they are, either in India or in Malaysia, in Singapore. I think that is good enough. So how to implement the law globally? This is a very tricky question. Basically, it very much depends on the supervisory authority in each country. I give an example about the extraterritoriality of the law. In Malaysia, in Singapore, in Indonesia, the laws basically has extraterritorial application. And it's very easy to say, but difficult to implement. But it has happened recently between what happened was the data was transferred to Canada from the UK. And there was an issue about a breach of the UK law of the company in Canada. So this is a real case, yeah? So the question was how the law in UK to be implemented in Canada, yeah? And when I read the case, to me, it's very interesting. It's basically the supervisory in the UK ICO collaborate with the supervisory in Canada to implement and to enforce the law in the UK. Perhaps that's the model that we should adopt in enforcing data protection laws around the world.
Thank you, sir. Which takes me to Attorney Temito. So my same question to you, as a follow-up question to what Professor has said, that what is the situation for cross-border sharing of data across the African nations, I would say? Is there any mechanism, any regulatory authority? Like for trade, we have various organizations like BRICS, there is the United Nations. For the international forefront, is there anything in the African continent to ensure the data protection cross-border amongst the developing nations?
Okay. So thank you very much. So we have the Malabo Convention that is passed by is under the African Union, and it's to enhance sharing of data across Africa. And again, we usually ensure, that we have standard contractual clauses such that parties are bound by data protection laws. So, for example, if two parties in different countries wish to share personal data, they would adopt a particular data protection law in a particular country, and they would also ensure that their standard contractual clauses, such as the third-party data processing agreements. And the NDPC in Nigeria also requires that there is a DPIA conducted when a party wants to share data, or if you are trying to engage in a new or explore a new technology that's not been used before, there's a DPIA that is conducted, and depending on the result of the DPIA, if its impact is going to be severe, then you need to share that report with the NDPC. So there are actually laws, and there are also steps that need to be implemented, such as the signing of a third-party data processing agreements, which can also be likened to standard contractual clauses. And also, the party receiving the data is required to have certain frameworks in place. That party is required to be as proof of compliance with the data protection legislation where that party is situated. So if we are entering into a contract with an entity in South Africa, my organization will need to see the evidence of compliance with the requirements of the information office that implements the requirements of the POPIA, which is data protection law in South Africa. So, and we'd also need to see the audit compliance certificates as well, which is one of the requirements under the NDPC. So it's basically ensuring that the data protection requirements in a country of legislation is not whittled down. It is not negated in any way, even though you are negotiating a cross-border transaction. So parties need to show proof to the other that the data protection legislation in each country is being complied with, and the steps required by the NDPC, such as the DPIA, third-party data processing agreement, and also the due diligence form is also well updated. And even from a technology point of view, we are the IT team, depending on the nature of the transaction, would also require SOC 1 and SOC 2 certifications, and also the ISO 27001 cybersecurity standard should also be complied with, by the party that wants to receive data or that wants to process data. So we usually require evidence of compliance with ISO 27001, because it's one thing for you to show compliance with data protection law, but you also need to see that from a technological point of view, you've also taken steps to enhance your operations, and that your operations are also optimal. The way you process data is in line with what is required by the law. So compliance, proof of compliance is one thing. I need to also see the how, which is the reason for the SOC 1 and SOC 2 ISO 27001 information security certifications. Thank you.
Wow, thank you so much. So this takes me to the next part of the discussion. Of course, before the closing remarks, I would like to say that, ladies and gentlemen, from what I have understood from this esteemed panel discussion, the laws may be made, but their enforcement, whether it's nationally, locally, or globally, is a challenge. So with that note and thought, I would like to start with the closing remarks, starting from Professor Abu, followed by Attorney Temitope, and thereafter Mr. Pagadia. Closing remarks, please.
Thank you so much, Mr. Moderator. I would like to echo what you have said. Having the law is good, but the law will have to be enforced effectively and efficiently for the law to work, because we have seen in some part of the world, yes, the law is there, yes, in the statute book, but it is not effective. But we have seen also in some countries, the law has achieved the objective of having the law. And again, I would like to refer to Singapore. Yeah, Singapore enacted the law 2 years after Malaysia enacted our law, and they have conducted few surveys basically, and the compliance level is very encouraging. And the conclusion is that the law has achieved the objective it tried to achieve when it was enacted. So having a law is good, but implementation is another big challenge for the supervisory authority. Thank you so much.
Thank you. Over to you, Attorney Temitope.
Thank you very much. Thank you. I'm grateful for this opportunity, and I've also learned from Professor Abu and Attorney Raj as well. Thank you.
We would like to have your closing remarks on this issue. What would you like to say?
Okay, so yeah, Yeah, basically, drawing from what Prof said, yes, it's good for you to have the laws, but you should also have implementation and measures. And I'd like to say very importantly, and even before implementation, I think there should also be a time frame to raise awareness, and awareness has to be on an end-to-end basis. Both the data subject, data controller, and the data processor need to be aware, of their rights and of their obligations as well. So I think awareness is actually one very key point. While the bills are being drafted, invite the public for public opinion. Invite the consultative forums, to give their nudge to the law as well, and key experts across various sectors, because data protection laws cuts across various sectors, both the non-technology and non-technology sectors. So I think stakeholder involvement is very important, and also driving awareness before enforcement as well, so that the law is not just seen as a stick. Thank you very much.
Thank you. So let's move on for the closing remarks of Mr. Raj Pagaria.
Thank you, Mahir. I would like to thank you at the outset and the Bar Council of Punjab and Haryana for inviting me for this panel discussion. And as my fellow panelists and I have discussed so far, that having a law is one thing, implementation is, of course, a challenge. And I'd just like to add a small thought to this, that I think India or South Asia or Southeast Asia at large, we are not a pro-compliant society. The top businesses might as well comply, but when it comes to middle and small level businesses, we may not be inclined to comply, because most of the business owners are going to see compliance as an operational expense. So unless they start seeing it as an investment, we'll continue to face this problem of compliance. But I think that's where the laws and the discussions happening everywhere play a part in create awareness among business owners that, see, you need to comply with this. This is important. And I hope that in the next 5 to 7 years, we will see more of these discussions happening, so that the overall efficiency or the implementation of law can further improvise. Thank you so much.
Thank you so much. With this, as we conclude, I extend my deepest gratitude to our speakers for their invaluable insights and our attendees for their active participation. We know you are busy with your work. You took out your valuable time. The Bar Council of Punjab and Haryana is extremely grateful for that effort and the benevolence and indulgence by you all esteemed panelists. It is clear that navigating data protection laws requires a nuanced understanding of both global trends and local realities, from what I have understood. And this session has rather reinforced the importance of international collaboration, innovation, and adaptability as well. On behalf of the Bar Council of Punjab and Haryana, I sincerely thank Temitode, Professor Abu, and Mr. Raj Pagaria for sharing their expertise and opinions on these vast but important and rather hot trending matters. I also express my appreciation to the organizing committee for their efforts in making this event a huge success. We look forward to continuing this crucial conversation, and we hope to see you all at the future events. With this, ladies and gentlemen, I want to thank you all once again, and you may have a wonderful day ahead. Namaste.
Namaste.